Good morning. Today I am going to inform you very urgent and necessary must information for all criminal practicing lawyers, particularly who are filing appeal and pending appeal when you file bail applications. There were earlier what happens when I was started my practice. We used to file bail application simply stating that for the reasons set out in the accompanying memorandum of grounds of appeal, the petitioner prays that this honorable court may be pleased to suspend the sentence wide judgment dated so and so in SC number so and so on the file of so and so, convicting the appellant under section so and so to imprison for life and other things, and then semicolon be released in meanwhile pending disposal of the appeal, above appeal, and render justice. Then the data that matters, counsel for the petitioner appellant, then the petition is confined at central prison and sued to the satisfaction of so and so. Next column down the counsel for the petitioner's signature. Then third one was that the fine amount whether paid or not. But later on, what happened? Some of the division bench judges wanted that there should be some history of the petitioners. What was he doing? Whether any previous cases are there? Whether what was the number of application earlier filed? What was its disposal? All those things they say. This is what we are doing now. What happened? Suddenly, Justice P.N. Prakash insisting us to file grounds in the suspension of petition also. Grounds in the suspension of petition also. Because there in 2005 there was an amendment wherein provided that the 389 class 1 proviso, the appellate court shall, before releasing on his bond or convicted, who is convicted of offence punishable with death or imprisonment for life or term less than 10 years, shall give opportunity to the public prosecutor for showing cause in writing against such release, provided further that in the cases where convicted person is released on bail, it shall be open to the public prosecutor for prosecutor to file cancellation of bail. Now, according to the present division bench headed by Justice M. Sundar and Mr. Justice Saktivel, they insist that what all are the main points for consideration of bail should be stated in your suspension of sentence. If that was not stated, the honorable bench says, how, if you have not raised that point, how the public prosecutor would file his objection. So only after filing his objection, the court can consider whether you are entitled for bail or not. This is therefore, if you want a clinching point, starring point, and vital point or prima facie point, to presume that prima facie there is material point arguable, therefore that point should be clearly stated. So yesterday there are in presence of there were 3 bail suspension of sentence applications were not considered because the point argued was not stated in the suspension of sentence. This is vital information to you. Therefore, kindly see, even one of the young lawyer seems to be very brilliant. He argued that we have stated that the already grounds in the appeal. Even in one of the bail applications, they say the ground stated in the appeal may also be considered for suspension of sentence. Despite that, the division bench insisting that what was the starting point specifically state. So that stage of transformation of procedural law is now being imposed on us. So be careful about that. That is when. Then I will share the history of the bail petitions. See what happened when I have started my practice. We used to file bail application before lower court by writing manuscriptly. Simply it is prayed the sound God may be pleased to release the petition on bail at all. Crime number top accused, that's all. That was considered 437 CR. Thereafter what happened, then slowly printed forms are used. Before the sessions court we used to file bail applications simply, and that was considered. For fun's sake, you know what is meant by copies received, copies not received. Sometimes it had happened before the sessions court. If the public prosecutor submits that copies received means call fees, quarter fees received. Copies not served means he did not considered for that earlier representation. So by appreciating that the courts are used to grant bail, anticipatory bail. This was the stage one. You know, see when we used to file bail application before principal session judge only, even for NDPS cases. So when after amendment of NDPS Act, a substantial law was introduced, it was the first principal session judge Krishnaswamy objected to that bail application maintainability, stating that in view of the special court or in view of section 37, bail application must be filed. Even you say here before the NDPS court, they are filing bail application 439. It should not be filed under the 430. It should be filed under section 37, read with 439. That's the first major provision. Grant of bail is contained in the substantial of NDPS Act. That should be there. Yeah. Like that, whenever you file bail application or anticipatory bail application for Essential Commodity Act, you have to file under section 12AA of the said Act. These things should be concentrated. Those who are really interested and the aspiring candidates for judges must also concentrate all these things. I hope you understand my endeavor or my interest in sharing this information with you. I hope you understand. Best wishes.